So when you say Virginia law is perhaps detrimental to clients, that's mostly because the forms are getting developed by the landlords, and in Virginia the contract is going to define the relationship. So if you have a good contract, that's great for you. If you have a bad contract, you're pretty much out of luck, right?
Yeah, that's totally it. But also just the way leasing and contract law have evolved. In general, very rough generalization, the states in the Northeast, Mid-Atlantic, are more tenant-friendly. They've adopted more contract law principles to real estate. Whereas, again, rough generalization, the South, Texas especially, more old-fashioned real estate principles where a lease is a conveyance, not a contract, and it's just tougher for a tenant. Things like how much rent can the landlord demand after a default, what kind of mitigation the landlord has to take, what kind of assignment rights the tenant and the landlord have in the lease. But again, if you have a strong lease form, the common law or the statutes law are much less important because the four corners of the lease governs and not the law. So normally, the more lease provisions you add would make the local law less important. Now, I should add, on a residential lease, which we're not talking about for this discussion, the local law is paramount.
Whole different ballgame. Virginia Residential Landlord-Tenant Act would control.
The thinking would be that the state, the counties, the cities have to protect residential tenants much more than they have to protect a commercial tenant. Less sophisticated, an individual, it's their home. So things like notice, what the landlord has to provide, that's all set forth in the Virginia Code for a residential tenant. But for a commercial lease, it really is the lease that governs. And if the lease term is not included, you look to the common law typically, which normally favors the landlord.